Hello, welcome to Workplace Wake Up. I'm Jen Shaw. Every week, I spend about 15 minutes covering key legal developments, introducing you to interesting guests, and providing some entertainment to start your workday. I hope you enjoyed this week's episode. We have a doozy of a development to talk about. I'm sure all of you have been following it very closely. If you've ever had anything called a PAGA claim, Private Attorneys General Act claim, you know exactly what I'm talking about. These are those pesky wage hour claims that really can cost you a ridiculous amount of money for something that really isn't that big of a deal. It doesn't even mean that your employees lost any money. I mean, it's just been the biggest boondoggle on the planet since 2004 when it became law. And really, none of us in the employment law field can figure out like how this made it through the legislature in the first place in 2003 to become law on January 1, 2004. But it did. We've been in HE double toothpick ever since. And last summer, there was a movement to get an initiative on the ballot where the voters could completely invalidate PAGA. So that got the legislature moving, which is what we all hoped, trying to avoid a total invalidation and save some of their precious law for their constituents. And of course, what's interesting is if your constituents are workers, the workers have not been benefiting from PAGA. If you've ever been the recipient of a PAGA settlement, maybe you got $500, usually not more than that. The real winners have been the lawyers who are pursuing the cases and the lawyers who are defending the cases. So what the heck happened? Well, on July 1st, earlier this week, Governor Newsom signed two pieces of legislation, and they are two laws that are now in effect that are really going to change the landscape in terms of PAGA cases. Now, the first one is AB 2288. This bill, now a law, significantly changes Labor Code Section 2699, which is really the heart of PAGA. It's really the Labor Code provision that sets forth all of the penalties, all of the violations, etc. AB 2288 makes a number of changes to PAGA that are effective to civil actions or notices that were filed with the Division of Labor Standards Enforcement on or after June 19th, 2024. So some of you may be slipping in under the proverbial wire here in terms of whether your cases may be covered by the amendments. But my own view on this is whether or not they are technically covered. Plaintiffs' lawyers are really going to be looking at these cases much differently after this legislation. So I think you're going to benefit even if your case was filed before. So there are a number of provisions that we're going to talk about there. SB 92, that Senate Bill 92, is a counterpart to AB 2288. It made a bunch of procedural changes to Labor Code Section 2699.3. And these are changes that relate to all sorts of provisions in terms of timing, notices, that sort of thing. So lots of developments here. So what I want to do is I want to go through some of these changes for you and highlight practically what you need to know here. So one of the things that I think is really important that these, particularly AB 2288 is changing, is standing. Okay, remember that to pursue a lawsuit, the plaintiff, the person suing, has to have standing. And what the new laws require is that the plaintiff has to have personally suffered all of the labor code provisions that they're seeking to pursue. Now, remember, PAGA cases are pursued on what we call a representative basis. So I could file a PAGA claim and I'm suing on behalf of all my coworkers, current and former, who are what we call similarly situated. They may not even know there's been a claim, but I'm pursuing one. Until this legislation passed, I could pursue a claim even if I didn't have a violation. It was crazy, to be honest. So one of the things that the new law is making clear is that the individuals who are suing have to have actually suffered the labor code violation. So if they're suing for an improper wage statement, their wage statement has to have been improper. If they're suing for overtime that wasn't properly calculated based on the regular rate of pay, their regular rate of pay has to have been miscalculated. So that is a very important part of the new law. Not only that, but the PAGA plaintiff has to have personally suffered each alleged violation within 1 year of them filing what's called the PAGA notice with the Labor and Workforce Development Agency. So that's part of the Department of Industrial Relations, same agency that the Division of Labor Standards Enforcement belongs to. That's where these notices are being filed. Previously, a PAGA plaintiff could have argued that, well, I was a victim of this labor code violation. Maybe it was more than a year ago, but I was a victim, so that's good enough. Not anymore. So those are two very important standing issues that are coming as a result of this legislation. So the second part of this legislation is that trial courts can now limit the scope of PAGA claims to make sure they're manageable. This is something that the California Supreme Court said was not in the law before. Remember that the courts can only interpret the law and they can't make the law, at least they're not supposed to. So now the court is going to be able to say, wait, there's just too much here. We have too many claims. We have too many people, too many employees. So they're going to be able to manage the litigation a little more effectively. Now, this part of the new law is going to cause a lot of litigation, I think, because what's happening is there's nothing in the new law that describes how the trial courts are going to be able to do this, how they're going to actually be able to make things a little more efficient. So be prepared for some litigation on that front, but at least we're going to be getting a little bit more availability for the courts to say this is just too much. It's not right for the employer. They can't possibly address all of this. I can't address it as the court. We need to get involved here. Now, another significant issue here are reductions in the PAGA penalties. There are a number of changes where these PAGA penalties are going to be reduced or eliminated. And part of that is really because what we call the cure provisions, the ability of the employer to cure a PAGA violation, is going to be greatly expanded. And also employers are going to be rewarded for taking what the law calls all reasonable steps to comply with the labor code. So there's a lot going on here in terms of, first of all, the need for employers to take every possible action to comply with the labor code. If there was ever a time for you to focus on prevention and compliance and audit your practices, this is it. You've got to be sure that your house is clean before a PAGA case is filed. By the way, some of you are thinking, well, didn't everybody already want to do that? Well, here's the interesting issue. Because PAGA was so draconian before these changes this week, a lot of employers just threw up their hands, quite honestly. They said, you know what, these plaintiffs' lawyers are going to find something, and I'm not going to get enough of a benefit to make it worth my while to go through all these changes right now. So just let them bring it on. We'll duke it out in mediation, and then I'll figure it out. Now there is a real motivation for employers to get this right, because if you can show that you took those reasonable steps, a claim cannot be filed. So the claim will either be thrown out or the penalties will be reduced. So there is a lot going on there. And I mean significantly reduced penalties to 15% of what the prior penalties were. So that's very important. So these cure provisions are going to be a significant part of this new law, because they're really going to give employers the ability to avoid a lot of what before, frankly, was just a foregone penalty, just a foregone conclusion. The other thing is there's going to be very small penalties for what they call technical or harmless violations. Things like wage statement penalties may be capped at $25, depending on how it's litigated, and maybe go up to only $50 instead of the current $4,000 per employee. So that's important. Also, the subsequent violations provision of PAGA, which says, okay, for all the pay periods where you keep doing this, we're going to charge you a lot of money for that. Now there's going to be a grace period. And if you've got the right policy in place and you're doing the right thing in terms of compliance, you're going to be much better off than you were before these laws were actually passed. There's also a prohibition on what we call derivative PAGA penalties. These are penalties where somebody has, for example, an underpayment of wages, and then they want a derivative violation for a wage statement violation, or a derivative violation for failure to pay wages when they separated. So now employees are not going to be able to seek derivative penalties unless they can show that the underpayment was willful or intentional, or knowing or intentional when it comes to the wage statement penalties. So this is a big deal. Now, I realize I'm giving you a lot of detail here. You don't need to memorize all this. You know, the only thing you need to remember is get your house in order. Like I said before, if there was ever a time to get your wage hour policies and protocols and processes in place, it is now. Now, another big part of this legislation is what they call early case resolution. So there are going to be a number of mechanisms where an employer, depending on their size, can actually request a stay of litigation and actually cure the problem. Now, those provisions, what we call the cure provisions, are not operative until October 1, 2024. But they're going to apply to any PAGA actions or notices that were filed after June 19th, 2024. Another part of this legislation that I personally love, because we have a fabulous client who's been on the wrong side of this. If you've been paying by the week rather than every other week or every 2 weeks, you have had double the penalties under PAGA, which just doesn't seem fair. So they are now eliminating that unfairness in the new law, saying, look, it doesn't matter if you're paying weekly or biweekly or bi-monthly. So that is going to be really important for those of you who either are required to pay on a weekly basis or for operational reasons have decided to do that. There are some other reforms that allow employees to keep a larger percentage of a PAGA settlement, which I think is great. They're now going to receive 35% of a recovery instead of 25%. And they can actually get injunctive relief, which is good, because if there's an employer who's doing something wrong, a PAGA plaintiff can come in and say, okay, I want the court to order you to do it right. So it's not all about money. It's also changing practices to make it better for everyone in the workplace. So, folks, there's a lot to report on here. We are going to have a webinar on August 1st. It's already filling up, so you need to register soon. We're going to talk about what we call the $1 million violation, which are these PAGA claims, and how to take advantage of these PAGA reforms. So now that these two laws have passed, AB 2288 and SP 92, make sure you sign up for that webinar. We have limited space, so make sure you get on it. You're going to want to hear about all of the details and the proactive steps you can take to take advantage of the new laws. It's not just going to happen by itself. You're going to have to take advantage, and now is the time to throw the resources at this issue. So everyone, thank you so much for joining me today. Go out and have a very safe and sane 4th of July, and I'll see you next time. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. If you enjoyed this episode and would like to spread the word, please share it with others, post about it on social media, and/or rate and review it. You can also follow us on LinkedIn, Twitter, and Facebook, and email us at info@shawlawgroup.com.